This is Paul Turner, the immigration barrister at Imperium Chambers, bringing you yet another update on the Balajigari fallout or issues resulting from the case. And there are two topics I intend to cover very briefly, so hopefully you're still awake at the end of it if you're not sick of listening to me talking about this particular case. The two issues are the consequences of the stay order of the 14th of June 2019 and orders that were made consequential to that, and secondly the right to work. Now, turning to the first issue, which is the stay order. As you recall from my earlier videos, it was agreed that the Home Office would file their position statement on 23rd of July and the applicants would file theirs thereafter in response. As I've stated on a number of occasions, Balajigari was a fantastic result in that it was found that the way in which the Home Office, and I stress the way in which the Home Office dealt with the applications was found to be illegal. It does not say that everybody that's made an application and has a tax discrepancy is entitled to ILR. It basically says the Secretary of State needs to go back and do a job properly. This, as I say, is dangerous because it could potentially lead to people being interviewed, disbelieved, and then being refused and then having to seek judicial review. So that's the first issue. The other issue are the consequential orders as to what's going to happen with all the other judicial reviews in the upper tribunal and in the Court of Appeal. Now, the Secretary of State's position is you can wait in line, we'll get round to you at some point, you can withdraw your judicial review and be a good boy. Now, I understand, and I've seen evidence from the court, that in Albert and Balajigari, the applicants didn't file any response to the Secretary of State's position. None. Nothing. In my case, in the two cases that I was representing, the responses I filed were essentially that people should be put back into the same position, if not granted Section 3C leave. They should be granted at least a right of work, and they should be granted all the other benefits that they had prior to what we now know were illegal decisions, rather than just being fobbed off and told to wait. Now, there's also another issue which wasn't touched upon in before, but I have raised the issue, or sought to raise the issue, is what about those individuals that have bought judicial reviews or appeals in the Court of Appeal and have simply run out of money living in the United Kingdom? It's not cheap to live in the United Kingdom. Where do they stand? In the Secretary of State's position statement, there's absolutely no provision for them at all. They could essentially withdraw their JR according to the Secretary of State and then have another go. It'd be difficult to see how they're going to conduct an interview or carry out the appropriate process if the individual is living in a small town in, say, the subcontinent. But there you are. I've seen fit to raise it. And I'm waiting on the Secretary of State's response and have been in touch with the government legal department. There's an awful lot of gossip in the Tier 1 world, but I advise people to look at facts and only the facts and see what happens. As I say, it is yet to be agreed as to what's going to happen in these cases. There may be some agreement. If not, there may be a further hearing before the upper tribunal pronounces its decision. The danger that there is, and I'm quite frankly surprised as to why there were no responses filed in Albert and Balajigari, the danger is that the upper tribunal endorses the Secretary of State's approach and says, well, these claims are all academic, you can withdraw them, wait in line for your turn to be re-interviewed, etc. Now, as I said, that's not my position. I set out my position quite clearly. Individuals back to the state they were prior to what we now know are unlawful decisions. Also, individuals that have left the country should be facilitated their return so that they are put back into the position. Now, turning to the second issue, the right to work. I've noticed a growing trend in what appear to be bowel variation forms or letters from the Secretary of State, where it sets out the background to the Balajigari litigation and then goes on to say that individuals have got the right to work and the right to study. Now, undoubtedly, that's very good news in that individuals are, in theory, able to go and get work and get jobs. However, and I'll be touching upon this on another broadcast, in respect of individuals with Section 3C leave, not merely a bowel form that says that they have permission to work, in that employers are often reluctant to take on individuals that don't have a biometric residence card, for obvious reasons. There's a £20,000 fine if you're caught employing someone that's not legally here, and how do you know that the piece of paper that you've got is genuine? And even if they can be bothered to do an ECS check, again, an employer might be reluctant to employ someone in those circumstances. Plus, there's a further factor that having won the judicial review and having succeeded in court, why should an individual have to produce a bail form saying that their condition of bail, which infers that they're liable for detention or that they're liable for further administrative action against them, have to show such a piece of paper to a prospective employer? It's hardly a ringing endorsement of the candidate's ability or even permission to remain in the United Kingdom. Perhaps there ought to have been a more fairer way around it. Perhaps Secretary of State ought to have just issued something, a blanket statement, a letter, an open letter, indicating that all those individuals are not to be treated as if they are crooks, criminals or deceivers, and should be treated as if they did have Section 3C leave. Indeed, I've had a client who is quite frankly and quite understandably embarrassed at the prospect of going to an employer with a letter that is essentially, you've been allowed to stay in the country, you haven't got a right to be here, but you're allowed to work. If I was an employer and someone produced that to me, unless they were of exceptional ability, I would be highly reluctant, even with an ECS check, to take them on. As I will turn to in a subsequent broadcast, individuals with even Section 3C leave are subject to being dismissed, and unfortunately in certain cases the Employment Tribunal doesn't seem to understand the difference between Section 3C leave and normal leave. But as I say, that's a matter for another day. So concluding this part of it, yes, there does seem to be a shift, and it seems to be a policy shift in respect of allowing individuals to work and to study pending the review of their case whenever that's going to take place. However, that's a matter that troubles me, and I would have preferred something better than just a mere letter. What I would suggest, by way of perhaps try and militate or reduce the effect of just having this brown piece of paper and saying you can check on your computer, is to see your representative and get your representative to write a letter to the effect that you are entitled to be here, perhaps set out the background to the litigation, the fact that the Secretary of State had acted unlawfully, and this is a temporary measure while the Secretary of State reconsiders. And that's probably what I would say is the most immediate and obvious thing to do. As I say, if you do have an immigration problem, or someone in your family has an immigration problem, you can always contact me, Paul Turner, the Immigration Barrister at Imperium Chambers, on 0207 242 3488, or at Clerks at Imperium Chambers, or on my site, theimmigration.barrister.co.uk. I will continue to bring you updates as to how the matters settle, and I will continue to fight as hard as I can for the rights of not only my clients, but all those that have been affected by the Secretary of State's unlawful behaviour. Thank you very much for watching. This is Paul Turner, the Immigration Barrister at Imperium Chambers.